Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron?
You done messed up, Aaron!
Aaron is here, everyone. Welcome back for more SPTV, where every day's a great day. Not to be in a cult. Someone done messed up this time. Thank God it wasn't me for once. I don't like doing videos like this, especially when it involves people fighting the good fight against Scientology. But there's no escaping this one because it's out there. It's out there. The lawsuit against David Miscavige and Danny Masterson, known as the Bixler lawsuit. Chrissy Carnell Bixler and other of Danny Masterson's victims and some of their family members filed a lawsuit back in, if I try to get the date, I'm going to totally screw it up right now. But this was a lawsuit brought against David Miscavige, Danny Masterson, and the Church of Scientology International for the harassment, the nonstop harassment, intimidation, Scientology would call them its fair game tactics, that Danny Masterson's victims and their family members were subjected to after the case was reopened in 2016. Now, this is one of the 5 ongoing lawsuits against David Miscavige and Scientology. The Bixler lawsuit is one of the 2 that has the most teeth right now and is making the most progress and has the absolute best chances of getting David Miscavige in the hot seat of a deposition. So the Bixler lawsuit has already cleared the famous arbitration hurdle that pretty much all Scientology lawsuits face. And it was able to clear that hurdle because this lawsuit has to do with things that occurred after all of the plaintiffs left Scientology. So it was ruled that the Scientology's arbitration contract did not apply at all. The Bixler lawsuit has also cleared initially the anti-slap hurdle. Scientology pretty much hits every lawsuit against it with an anti-slap, saying, what? We are a religion and everything we do to you is protected religious activity. Okay, so where the Bixler lawsuit stands is Scientology tried to hit it with an anti-slap motion. Judge Kalra found 100% in favor of the plaintiffs. In other words, ruled 100% against Scientology with very, very strong language. Scientology said, my pearls, we don't like that. And they filed an appeal. As expected, this is what Scientology does every step of the way. Scientology filed an appeal brief. I think it was in May. The appeal brief finally landed. And the original ruling by Judge Kalra, the original ruling ruling against Scientology in their anti-slap motion was so strong that the Bixler team could have just not even bothered to file a response. They really could have just not even filed a response, and it probably would have been okay. But, I think it's good form to file a response, and they did. There's just one problem. Their response, they used an AI tool in the research to help them with the research that was done to file the response. And that AI tool made up imaginary lawsuits that didn't exist, cited imaginary lawsuits that didn't exist, referred to real lawsuits that did exist, but completely misrepresented what the findings of those lawsuits. It was not good. And so Scientology had filed its appeal. The Bixler legal team filed its response, and then Scientology had an opportunity to file its reply. And they filed their reply, and in the beginning of their reply, they basically informed the judge of all of the errors that the AI tool that was being used by the Boies Schiller firm made. And this is a massive humiliation for Boies Schiller. Luckily, in my opinion, as a layman, it should have no effect on the lawsuit itself. It certainly is going to have an effect on the Boies Schiller firm. So what I'm going to share with you is a Substack article written by David Latt that talks about this. David Latt doesn't do Scientology content. He does legal content. And anyway, I think his article is pretty enlightening. And I want to share it with you because he actually describes this as the biggest, let's say, flap, the biggest AI flap to hit big law to date. And it's so unfortunate that this unforced error occurred in a lawsuit involving Scientology, because Scientology's lawyers are going to take this to the ends of the earth. Please don't be surprised if Scientology's attorneys, move for big sanctions. They're not just gonna settle for whatever. They're gonna make hay out of this. Okay, let's look at the article. Title: An AI fail by an elite litigation firm. All right, let me close that up. Thank you very much. An AI fail by an elite litigation firm with a Vault 100 and I got to be honest, because I've already read this article, I have inferred what Vault 100 and AM Law 200 mean, but I don't even know if I'm saying it right. Is it AM Law? Is it AM Law? Does AM Law mean American law? I don't know, guys. With a Vault 100 and an AM Law 200 firm at its center, this might be Big Law's biggest artificial intelligence mishap to date. Okay. As Andy Warhol is famously credited with saying, in the future, everyone will be world famous for 15 minutes. Here's what I'm wondering. In the future, will everyone be world famous for 15 minutes for an AI screw up? Why do I say this? AI mistakes are no longer the exclusive province of the wantonly stupid. Ooh, yikes. They can even be committed by leading litigators at famous firms. Meet John Kucera, a partner in the Los Angeles office of Boyce Schiller Flexner, whose firm bio describes him as a former prosecutor with extensive experience in high-profile litigation. According to his LinkedIn profile, Kucera has been practicing for more than 20 years, including more than 12 years spent as a federal prosecutor in the Central District of California, aka Los Angeles. As for Boyce Schiller Flexner, the firm needs no introduction. The firm, founded in 1997 by the celebrated trial lawyer David Boies after he left Kravitz, Swain, and Moore, today BSF is one of the most prestigious and profitable law firms in the nation. It's currently number 55 in the Vault 100, the nation's 100 most prestigious law firms, and 118 in the AM Law 200, the country's 200 largest law firms based on revenue. Alrighty. Boyce Schiller Flexner is well known for representing plaintiffs as well as defendants, and some of his plaintiff side clients are victims, most famously the victims of the late Jeffrey Epstein. So it shouldn't be surprising that John Kucera and BSF represent victims of actor Danny Masterson, who was convicted in May 2023 of raping 2 women. In their civil case filed in California, now I'm going to jump in right here because now it says in their civil case, which makes it sound like it's one of those lawsuits where you get a criminal conviction and then you file a civil lawsuit for basically the exact same thing. But remember, this civil lawsuit was not against Danny Masterson for the raping. It's not against Scientology for covering up the rapes. It's for the harassment the victims, who were all out of Scientology at the time, the victims were subjected to, the harassment that Danny Masterson's ex-Scientologist victims and additional parties were subjected to after the case was reopened. I just really like to clarify that. Okay. Okay, it should be no surprise that they represent the victims of Danny Masterson, who was convicted, blah, 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 blah. Okay, I'm sorry. Why am I getting myself so twisted around here? Okay, in their civil case filed in California State Court against Danny Masterson and the Church of Scientology, to which Danny Masterson belonged, and Scientology's leader, David Miscavige, the 5 plaintiffs claim that after coming forward about Masterson, they were subjected to a relentless campaign of harassment, surveillance, threats, and defamation, both online and offline. Scientology filed a motion to strike under California's anti-SLAPP statute. After Judge Kalra of Los Angeles County Superior Court denied the motion, Scientology appealed to the California Court of Appeals for the 2nd District. Scientology filed its opening brief in April. The plaintiffs filed the response brief. And then Scientology filed its reply brief, which began as follows. Before addressing the merits of this appeal, in the introduction section below, we wish to draw the court's attention to the fact that plaintiff's brief contains a series of troubling citation errors. The portions of the brief containing errors bear many of the hallmarks of AI-generated case citations. A table detailing the errors we identified is included as attachment A at the end of this brief. Multiple sections of plaintiff's brief are filled with erroneous citations that mischaracterize holdings and refer to cases on unrelated areas of law. Some cases are mistitled, such that it is difficult to determine what cases plaintiffs are intending to cite in the first place. And one case plaintiff cite is completely made up. At minimum, the court should disregard these sections of plaintiff's brief and find the arguments plaintiffs make forfeited. Yikes. This sounds bad. And it turns out to be true, as Kucera acknowledged in BSF's motion for leave to file a corrected response brief, which he filed last Friday. Here is the relevant portion of the declaration submitted by Kucera in support of the motion. Quote, I was and am the sole firm partner with responsibility for overseeing the preparation and filing of the filed response brief in this action. Under my direction and with consent of the individual respondents, the preparation of the filed response brief included the use of AI tools. The firm is committed to the responsible use of AI and has adopted policies and implemented trainings intended to protect against the risks of the improper use of AI. Independent of the use of AI tools, firm lawyers are always expected to scrupulously proofread and cite check the accuracy of the factual and legal claims in court filings. Notwithstanding these controls, the filed response brief included material citation errors, including those identified in appellant's reply brief. As the attorney and partner in charge of the filed response brief, I am embarrassed. I am embarrassed by and very much regret these errors. The firm is undertaking an investigation to determine why its controls failed and to ensure appropriate corrective action is taken. However, as the supervising attorney ultimately responsible for signing and submitting the filed response brief, I bear the responsibility for failing to personally verify the citations included in the brief. So unfortunate. I'll tell you, I was impressed by how thoroughly John took responsibility for the errors in his brief. I think someone would also argue, what choice did he have? I mean, what choice did he have? Okay, it does continue here. To his credit, Kucera fully and freely admitted the errors, and he didn't throw any colleagues under the bus, even though I'm guessing the brief was prepared in the first instance by associates whom Kucera did not name. No associates' names appeared on the original response brief. The only lawyers on the brief besides Kucera were two partners, Allison Anderson and Max Pritt. And in the proposed corrected brief submitted along with his motion, Kucera removed the names of Anderson and Pritt, presumably because they had little or no roles in this mess. I'm going to keep reading the rest of the article because there's some interesting takes. But I'll tell you, just to revisit one of the things I said earlier in this video, where my personal unqualified layman's opinion is that this embarrassing mistake should not, I predict, affect the judge's ruling in this appeal. Because as I said, Judge Kalra's initial ruling, the trial court ruling, because now this matter is before the appeal court, which I believe is a panel of 3 judges. But Judge Kalra's initial ruling in this case, which Scientology is appealing, was so thorough and so sound and so strong that really BSF and Kucera could have not even filed a response to Scientology's appeal, and everything probably would have been fine. So even if the appeals court panel, does what Scientology has somewhat requested, which is just throw out every argument that is based on any citation made, I really don't think it should matter. What do you guys think? Okay, let's keep reading a little bit more of this. Let me change my view here. Oh, this is interesting. It's interesting that the author has some personal perspective on this. Okay, so he continues. I can also confirm Kucera's statement that Boy Schiller is committed to the responsible use of AI and has adopted policies and implemented trainings about AI. For the past 2 years, I've moderated panels at BSF's New York offices about AI. And during these well-attended panels, which featured a BSF partner speaking alongside outside experts about AI, I've learned about the firm's innovative, cautious, and thoughtful approach to integrating AI into its work. That said, there's no denying that this is suboptimal. Involving a Vault 100 and AmLaw 200 law firm that's a litigation powerhouse, it is arguably Big Law's biggest AI debacle to date. Okay, the author goes on to cite some other AI debacles that have occurred, but goes on to explain how those other debacles have involved firms that did not have anywhere near the size and prestige of BSF. So we're not going to go through all those paragraphs because, to be honest, it just doesn't really matter. And I got to tell you, as a layman, some of the other thoughts that I had when I first found out about all this is like, as an attorney, as an attorney, not me, but as an attorney, in my opinion, an attorney, a litigation firm, would be absolutely crazy not to figure out how to use AI to help them in their litigation strategy and their prep and everything. Of course, you've got to put checks and balances in place, but you'd have to be absolutely crazy not to figure out how to use AI to increase your efficiency. And so I couldn't help but immediately sympathize for the mistakes that are inevitably going to be made along the way, especially as firms are figuring out the best, most responsible way to use this as a tool. I couldn't help but be very sympathetic that someone was eventually going to make a huge mistake. And I wish it wasn't John, and I wish it wasn't BSF, and I wish it wasn't in a Scientology lawsuit, but God damn it, it was. And so I was kind of pleased to get to this following section in the article. Okay, so it says, I think it is therefore fair to say that Boy Schiller Flexner is now the big law leader in terms of AI fails. But again, I wouldn't judge BSF too harshly, lest ye be judged. And this is a very funny story. Let's return to the quote I used to open this post. Quote, in the future, everyone will be world famous for 15 minutes. After ChatGPT confidently assured me that this quote was said by Andy Warhol, I plunked it into my draft without hesitation, attributing to Warhol. But when I conducted a confirmatory Google search before publishing this post, I came across a Smithsonian Magazine article suggesting that it wasn't actually uttered by Warhol, which is why I revised my opening sentence to describe Warhol as being credited with saying, as opposed to actually saying the 15 minutes quip. So I came perilously close to a ChatGPT fail of my own. And while this is merely a Substack post written by a guy on a couch in his pajamas and not a brief filed in a court of law by a partner who probably charges more than $2,000 an hour, that was or should have been site checked by multiple associates and paralegals, it could have been embarrassing for me, especially in an article about AI screw-ups. I leave you with this parting thought. The next time you hear about an epic AI fail, instead of, or at least after, laughing your ass off, perhaps have the humility to say this to yourself: there, but for the grace of God, go AI. Go AI. Okay, funny little joke. But again, honestly, some real perspective, I think some good real world and honest perspective. Is this an embarrassing mistake? Yes. It's very embarrassing, but it's not devastating. And it should not affect, in my opinion, the outcome of this case. Let's hope to God not, because that would be utterly devastating. Now, when you have a firm as prestigious as BSF, when you have a partner, I got to double check this. I think Kucera has only been at the firm for 2 or 3 years as a partner. He joined as a partner, but I do think it's only been 2 or 3 years. Regardless of who actually made the mistake, would I be shocked to see John Kucera fall on his sword to the extent of actually leaving the firm? I don't think I would be shocked. I wonder if you guys think that would be an appropriate response. Like, oh, I feel like I can understand very, very strong arguments on both sides of this. on both sides of this. Meaning, I could understand the arguments, some of which I've kind of made in this video, that like, is this really the huge, huge, huge deal that Scientology wants it to be? Maybe, but it's also a mistake any firm could have made. Now you might go, yeah, but that type of argument just doesn't cut it when you're dealing with firms that are doing this type of work and charging this kind of money and represent massive institutional clients. Like, your reputation is everything. And when your reputation is everything, it just doesn't cut it to say anybody could have made this mistake. Yeah, anybody could have made this mistake, but nobody our size has. We're the biggest ones, and that's not the kind of precedent. It's not the kind of precedent setting you want to be a part of. Do you guys think a mistake like this would warrant John Kucera leaving the firm, even if only just to put this chapter to rest and to save the reputation of the firm? Do you guys think so? Because even though I don't think something like that should be necessary, I wouldn't be surprised to see it happen. And I'm sure Scientology will declare it a giant victory. And I'll tell you what, one of the things, like, as an ex-Scientologist who really, cheers on firms brave enough to take on litigation against Scientology and sink those type of resources into contingency-only representation, I would see it as a loss. Firms are taking a big risk when they agree to represent plaintiffs against Scientology on contingency. They know what they're in for in terms of harassment from Scientology. They know what they're in for in terms of the amount of years Scientology will drag litigation on for. Scientology will, harass attorneys on the other side. They're taking a big risk. And I can't help but wince when I see an attorney who has taken on that challenge, possibly now suffer this fate due to what is, let's be honest, a self-inflicted unforced error, an unforced error and a self-inflicted wound. And yet Scientology will declare victory. And I wonder if John Kucera or BSF made a mistake like this in a lawsuit that didn't involve Scientology. If the outcome would be different, would you guys know what I mean? Like, Scientology's attorneys are going to call for blood. They're going to demand blood. They're going to want their pound of flesh. Would it be so vicious if the attorneys on the other side, or if I should say, the defendant on the other side wasn't Scientology and the attorneys weren't representing Scientology? Because whatever behavior we see from the other side is, let's be honest, it's being dictated by David Miscavige. It's not being dictated by the attorneys. David Miscavige dictates to the attorneys. So that's what we have now. We're still, it still remains to be seen whether the appeals court panel judges will allow BSF to file an amended reply or not. We'll see. As soon as I have an update, I'll let you guys know. But yeah, I don't like highlighting mistakes on what I consider to be our own side. But as you can see, this one's unavoidable. I'm not the one breaking the news on this, and nor would I want to be. You know what I mean? Okay, let's look at some comments here. Nicole Kipp, welcome as a new channel member. Nicole Kipp, happy to have you. Max's mom, people rely on AI far too much without double checking it. It is so unprofessional. I hear you. I mean, AI, it's just the newest way that people can get things wrong. Anyway, I'll save my words. Old Frizz, this is so upsetting for the victims. When is their nightmare going to end? Yes. Can you imagine? Oh, of all of the unforced errors, this is not the one. Constance June, do not use AI in legal or lawsuits. My guess is courts do not think highly of AI usage. So unfortunate and so sad. I think what some of these big firms are doing is developing their own in-house AI tools that don't have direct access to the internet or direct access to ChatGPT or Grok or anything like that. I think what some of the big firms are trying to do is to basically upload primary material, like upload actual lawsuits to an internal AI tool and just use AI to help sort through case material, as opposed to using AI tools that have been trained on the internet, or trained on a data set that is basically the entire internet. That's my understanding. That's my understanding. I think it's absolutely amazing that the author of this article has actually been involved in panels at BSF on the ethical use of AI in preparation. Small world. Okay. Spock hates Scientology. I go on a big legal channel. From what I know, the law firm will get heavy sanctions for this. That is my understanding as well. They will get heavy sanctions. And those sanctions are probably going to come from the bar itself, right? Not even from the judge. I mean, maybe the judge will sanction them as well, but I think the bar itself gets involved. Abigail, see when not. Side question, Aaron, did you get some Amazon packages yesterday? Some spray chalk should have arrived. Abigail, I did get some Amazon packages from you and also from some others. In fact, yesterday I had to take a little break and focus on organizing all of my protest supplies. Over time, some of them are in the garage, some of them are in the car, some of them are in the kitchen, some of them are in the dining room, some of them are in the living room, and I had to consolidate. I had to have a container for powdered chalk supplies, a container for spray chalk supplies, a container for chalk stick supplies and related related items. I have to have a pile just for bubble machines. I have to have a pile for bubble soap. And I had to have a pile for my plastic powdered chalk squeeze bottles. Like, it's a whole operation. So yes, I did get some packages yesterday, including yours, Abigail. Thank you so much. Abigail says, maybe not leave the firm, but I wouldn't be surprised if he's dropped from the lawsuit, replacing him with someone else from the firm. Okay, that could be interesting. Old Frizz, I think the judge should allow the firm to refile the corrected response. Maybe sanction the solicitors somehow. Okay. Stephen Mark Katzman, AI or not, it amounts to fraud on the court. Yeah, that's kind of the thing there. Old Frizz, the judge should not make the victims pay for the lawyer's mistakes. I agree with that sentiment. Well, it's 9:30. There were so many more videos I wanted to do today, but it's 9:30. So we're going to call it a wrap for tonight. Thank you guys for hanging out with me. And yeah, what's today? Tuesday? All right, tomorrow's going to be a big day. Stay tuned. We got a lot of videos coming tomorrow. Thanks for hanging out with me, you guys. I'll see you guys tomorrow.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe